Hello and welcome to week 13 of business law. Last week we looked at debtor-creditor relations. This week we're going to continue our foray through the warm and cheery aspects of business law by taking a look at bankruptcy. We know that there will always be some debtors who get in over their heads. They're going to be so far into debt they will no longer be able to pay their bills. When that happens, they have reached a condition that we call being insolvent, when the money going out is more than the money coming in, or another term for that condition is bankrupt. At one point in history, not all that long ago actually, debtors who could not pay their debts with money were thrown into prison or made slaves, or what we call indentured servants. So they were kind of put to work against their will to work off their debt. And there are horrible stories about how this would work. Well, we're more enlightened than that. In our civilized society, we don't lock anyone up who can't pay their bills. Instead, we allow folks who reach this point in their lives to have a fresh start because we have a system of bankruptcy that allows them to pay off as much debt as they possibly can, but also forgive some of it and allow them to have a fresh start. That's going to be an unfortunate situation for their creditors, of course, because they probably won't get all of their money back that they loaned out. However, it is a good policy overall because it allows people to start over again and hopefully become productive participants in our economy. You might wonder, well, why is it good? How is that fair to wipe out the debts of these people who were, essentially deadbeats, who bit off more than they could chew, made bad decisions? Well, the answer is that really, if we were just to punish them for taking a risk, making bad decisions, they would never take a risk again. Probably, I don't know, I haven't seen the movie, but probably Steve Jobs, didn't succeed the very first time he tried something. Well, if the next Steve Jobs comes along and tries to start some brand new company, has a great idea, and it fails, he has to declare bankruptcy, and then we punish him for the rest of his life, and he, has to work at McDonald's so he can pay off his loans to his creditors rather than give him a fresh start. Is that really better than, giving him that fresh start and then letting him try again and take another risk and actually start a successful company that changes the world and, adds to the economy and creates all kinds of jobs. And in our market economy, we want to encourage some risk taking because if we don't take risks, we will never innovate, we'll never create new products and create jobs and do all those wonderful things that keeps our economy humming along. And so actually, bankruptcy is a net positive thing for the economy, as long as it's not abused. Of course, some folks will try to abuse it, but overall, we want to encourage that culture of, enlightened risk-taking. And if there's no way to shake off bad debts if you get in this situation, that's really going to damp down on that because everyone will be afraid to take a risk. And if they're afraid to do that, they'll stop inventing things and stop founding new companies and all of that stuff. And so bankruptcy is kind of a necessary evil in a way because it is what ensures that our economy will keep growing and innovating and we'll keep creating new products and adding jobs to the economy and that sort of thing. So that's why we have it. Well, Congress was given the power to pass laws regulating bankruptcy by the Constitution. Our founding fathers actually thought this was important enough to mention it in the Constitution. And so bankruptcy was an explicit power, express power given to Congress by the Constitution. And it's also an exclusive power. The federal government is the only one that has the power to handle bankruptcy. There are no state laws that are equivalent to bankruptcy, and there can't be because that's an exclusive federal power. So the bankruptcy process is entirely governed by federal law, with the exception of some exemptions that are figured out at the state level, but we'll get into that a little bit later. But the process itself is governed by federal law. All bankruptcy cases are heard in federal court, which is kind of weird in a way because we already looked long ago about the court system. You'll remember that 90% of cases throughout the country probably are handled by state courts, but bankruptcy is always a federal case. And there are courts in the federal system just for dealing with that. The federal statutes on bankruptcy are what we call the Bankruptcy Code. And Congress changes it from time to time. They made a big overhaul of it in 2005, the biggest changes in a long time, but they tweak it, constantly, just like they tweak the tax code. So it does change over time, but every once in a while they'll really get their knickers in a wad about something and change it in a big way. And the last big revision was 2005. In 1978, they had reformed it prior to that as a pretty big reform. That actually, in 78, made it easier for debtors to get out of debt. The 2005 law kind of went the other direction. It tightened things up and made it hard to say goodbye to credit card companies and other unsecured creditors because those credit card companies were pretty upset. They felt like it was too easy to dump their debt in bankruptcy. And so that was tightened up a little bit. There are a number of different types of bankruptcy named after the different chapters of the bankruptcy code, and we will take a look at those and kind of give an overview of all of it. Again, this is a huge subject in law school. There's an entire 3-hour class on bankruptcy, and so we're not going to get into all kinds of levels of detail, but we're going to kind of take a tour through it just to see how it operates, what the idea is, and get an idea of how the different chapters operate. And so if you're ever contemplating bankruptcy or one of your debtors, if you lent money out or something, if they actually go into bankruptcy, you'll kind of know what's going on. Anyway, the different types of bankruptcy differ on what the debtor is able to do with it and how it functions. And again, we will take a little tour through that and see how the different chapters operate. No matter which chapter is used, the goal is the same, and that is to give the debtor a fresh start by relieving him of some debts that he's never going to be able to repay. And, sometimes folks just get to the point where we understand it doesn't matter, how we change the terms, or whatever of the debt that they're in, unless we do something drastic, they're never going to dig themselves out of the hole. And so this is bankruptcy is designed for those sorts of situations. Even though we let them off the hook for some debt usually, the interests of the creditors are protected as much as we possibly can. And this isn't just a get out of jail free card for the debtor. The creditors, we try to treat them as fairly as we possibly can also. So overall, the law is designed to do a few different things. One thing is it protects debtors from creditors who use abusive tactics to collect debts. If you've ever had a bad debt yourself, you know how nasty it can get sometimes when creditors, especially collection agencies, if it's been turned over to them, how they will make your life a living nightmare by all the phone calls and things you get in the mail and showing up to bother you and all kinds of interesting things that they do. And so the bankruptcy law is designed to shield debtors from abusive tactics and things like that. It's also designed to make sure that all creditors are treated fairly without one getting some kind of unfair advantage over the others. And we'll take a look at, there are some mechanisms within the code that are designed to make sure that no one creditor gets an unfair leg up on the other creditors. It also is designed to protect creditors from debtors who would try to hide assets or otherwise cheat, because even though we're giving the debtors some pretty cool relief here by getting them out of debt, kind of erasing some of those obligations that they entered into, there are going to be those who would try to hide assets. And so, they don't really want to have to sell their Lamborghini to pay off their debts in bankruptcy, and they'll try to, deed it over to Aunt Flo or something, so nobody will see it. Well, there are mechanisms for dealing with that. Again, we'll take a look at some of those. And the overall goal is also to force debtors to pay the debts that they can pay, because, again, we don't just wipe the slate clean. We try to make them pay as much as they possibly can, kind of push them to the limit, and then let them off the hook for the rest if there's absolutely no way, in a reasonable amount of time they can ever pay them off, then we will take care of that. But we do want them to face up to as many obligations as they can, because, of course, they did enter into debt. That was their fault, so we do try to make them take responsibility for as much of it as they possibly can. With bankruptcy, we're always going to be in federal court, but the federal court system has special bankruptcy courts, and that's to avoid clogging up the regular federal courts with bankruptcies. They do take quite a bit of time sometimes to work through all the issues, and rather than having them just in the regular court system, they've created special bankruptcy courts to hear these kinds of cases. And the judges on those courts do nothing but hear bankruptcy cases. And that's really cool in a way, because they become bankruptcy experts. And so bankruptcy, like I said, can be fairly complicated sometimes. And so it's really helpful to have judges that do nothing every day except hear bankruptcy cases, because they get to be experts in that field and really know what they're doing. Since you have to declare bankruptcy in federal court, locally, what you would be dealing with is the Federal District Court for the Western District of Missouri, which is headquartered in Kansas City. They also have some branch offices, one big one in Springfield, and they'll even hear cases in Joplin from time to time. But normally you would be filing, if you're in this area, with that court. Hopefully you never have to, but I thought you might like to know that. Let's talk now about some basic bankruptcy procedures and just kind of in general terms how one of these cases develops. The bankruptcy case is started by filing a petition, and there are actually two different kinds of petitions. The first one is what we call a voluntary petition, and this one is filed by the debtor himself or herself. The petition states that the debtor has debts, says what his assets are, and that the debts are more than he can pay. So basically, it's saying, help, because the debtor has got himself in over his head. And so this is the debtor's idea to do this. The creditors are circling like buzzards, and the debtor has run out of money, and he can't figure out a way out of this mess, and so he files this bankruptcy petition. Well, that's one way. The other way is for an involuntary petition. And this one is interesting because it's not filed by the debtor, but by one of the creditors. And this happens when a creditor is getting stiffed by the debtor who's not keeping current with his payments. And so the creditor's out here is owed money by the debtor is not paying, and so the creditor says, well, if you're not paying me, you must be bankrupt, and hauls him into bankruptcy court. The creditor can force the debtor into bankruptcy court this way, and the creditor can get the court to organize the assets of the debtor and pay off as much of the debts as possible if he shows that the debtor is in fact insolvent and actually meets all the requirements of bankruptcy. The debtor, however, may not be happy about this arrangement, may not want to be in bankruptcy court, and has a chance to challenge the petition. And so we may need some kind of trial here with not with a jury probably, but with the judge, which will be held to determine if the bankruptcy proceeding should go forward or if the debtor in fact is really not insolvent. And so you can end up in bankruptcy court because you want to, hey court, please protect me from these creditors. Or one of your creditors, if you're stiffing them, can say, well, this guy must be bankrupt, and so we'll haul you into court against your will. So two different ways that you can end up before the bankruptcy court there. The 2005 update to the Bankruptcy Code did make a few changes in the bankruptcy procedures, and one of those is that debtors must receive financial counseling within 6 months prior to filing a voluntary petition. This is dealing with individuals who are going to declare bankruptcy. And we require them to talk to a financial counselor, because that might enable them to figure out how to get back on their financial feet and avoid declaring bankruptcy in the first place. And that's because bankruptcies are something we should try to avoid. They ruin the debtor's credit for 10 years. They end up stiffing some creditors for at least part of the money that they are owed. And these changes were made to the code largely at the behest of credit card companies and other consumer lenders who felt like the bankruptcy code was too debtor-friendly and was letting them discharge debts that they probably could have paid off if they'd had a little bit better advice. And certainly some folks see bankruptcy as an easy way out of their money problems, even if with some smart planning and hard work they could have turned things around without resorting to bankruptcy. And so this counseling is designed to divert as many people away from declaring bankruptcy as possible. And after the bankruptcy, debtors are required to take a personal financial management course so that they won't get into the same mess again. And I'll take a moment and say that if you declare bankruptcy, that's not a moral judgment against you. You're not necessarily a person of bad character, and sometimes folks get a rap for that. Sometimes medical bills pile up. Somebody gets into the hospital, or bad things happen. You lose your job, and things just pile up. Debts get more than you can handle, and people have to declare bankruptcy. But sometimes people give bankruptcy or people who declare bankruptcy a bad reputation by resorting to it too quickly. And you can understand why they would when we look at all the advantages, such as the automatic stay that makes those angry phone calls from creditors stop. And sometimes people resort to it a little too quickly was the view. And so Congress put these things into the code to make sure that bankruptcy is the last resort that it was intended to be, rather than an easy out for people to take just because they made poor decisions and racked up a bunch of debt that they couldn't repay. So again, people who declare bankruptcy aren't necessarily bad people, and even though these provisions of the code make it seem like they aren't good money managers, but this is just designed to make sure that as few people actually end up as bankruptcy as possible, because it's really it's harmful to their credit. It's harmful to the creditors, and so we want to avoid it as much as we can. All right, well, after we get past that, after the petition is on file, the debtor must submit what we call schedules. And in the law, especially, if you ever take a tax accounting class or something, you'll deal a lot with schedules. It sounds like a schedule is, a list of when things are going to happen, like your TV schedule, but not in the law or accounting purposes. We're talking about lists of things. And a schedule that you're supposed to submit for bankruptcy is a list of, first of all, who your creditors are, how much you owe them, how to get a hold of them, so that we know exactly how much you owe, and we'll be able to get a hold of them and let them know that you have declared bankruptcy. They'll be contacted, allowed to present their claims to the court. On those schedules, you also have to list your present financial information, including your income, all of your assets, all the property that you own, because again, we're trying to figure out, are you really bankrupt? Are you insolvent? Are your assets smaller than your liabilities? And if they are, what are we going to have left to pay off your debts with? Hiding assets from the bankruptcy court is a very serious federal crime. Remember, we are in federal court. This is federal law. And so if you try to, park your Lamborghini in Aunt Flo's garage so the bankruptcy court doesn't find it, that's going to be something that could land you in federal prison. So that's not a good thing at all. And a bankruptcy attorney has a duty to investigate the debtor's estate, make sure that all the information is accurate. And so, there is attorney-client privilege there. You're supposed to trust your attorney, but your bankruptcy attorney is also an officer of the court, and so can't sign off on something they think is shady. So they have to do their due diligence to make sure that you've actually listed everything that you're supposed to list. Once all that basic information is on file, the court will issue what is called an order of relief. And that just means that the case is accepted into the bankruptcy court and that they will continue to hold bankruptcy proceedings on your case. Within 30 days of that, there will be a meeting of the creditors, which is all of your creditors show up and they get a chance to question the debtor under oath, find out about his assets and his ability to pay, and just kind of take stock of the whole situation. Is kind of how this gets kicked off here. In most types of bankruptcy, there will be a bankruptcy trustee that is appointed. And this person, again, is an officer of the court who is kind of put in charge of your bankruptcy case to make sure that everything goes according to plan. And they will handle the day-to-day issues that come up with the bankruptcy estates that they are in charge of. And they will be in charge of managing the assets of debtors who have declared bankruptcy. So they're supposed to oversee things and make sure that your property, your assets that do exist, are managed in such a way that they will be used fairly to pay off as many creditors as possible and that sort of thing. So they will take charge of the debtor's assets, making sure that no money disappears that could be used to pay off debts, also making sure that everyone is treated fairly. They have the power to take possession of the debtor's property. They will be digging around, trying to investigate the debtor's finances and to investigate the claims of the creditors and determine whether or not these creditors are actually entitled to the payments that they're claiming. And eventually, following the orders of the bankruptcy judge, they may be able to sell the debtor's remaining assets and distribute the proceeds to the creditors. And so this is, basically this bankruptcy trustee is an officer of the court, is given charge of the debtor's estate, just to make sure that it's not mismanaged and that all the orders of the bankruptcy judge are carried out, and so that the creditors are treated as fairly as possible and as the debtor is as well. So the debtor files the petition, the creditors are notified, and once the creditor has been notified that their debtor is declaring bankruptcy, he must file a document called a proof of claim with the bankruptcy court. This document will tell the court how much the debtor owes the creditor. If the creditor is secured, he's also going to tell the court what the collateral is and will probably get priority as to that collateral. And if the debtor owes more than the collateral is worth, then the creditor can get an unsecured claim for the difference in value. So again, it works fairly similarly to what we saw happening with the secured transactions situations we were looking at last week. Very similar kinds of a system here. Once the bankruptcy is filed, the debtor and his property are immediately protected by what is called an automatic stay. And this is really the thing that is most attractive to bankruptcy for a lot of folks who are in financial trouble, because this makes creditors stop trying to collect debts from the debtor. who has declared bankruptcy. So as long as that automatic stay is in place, they cannot file lawsuits to try to seize your stuff and collect on debts. They have to stop the phone calls, and the wage garnishments and all that kind of stuff has to end. So they have to halt all of those activities, and instead of that, they have to bring all their claims to the bankruptcy court. And so the bankruptcy court, in a way, is kind of like the big brother that comes in to protect the poor little debtor and says, stop harassing them, bring all your claims to me, and we'll figure it out. And so that's really attractive because if you've ever been harassed by creditors, that is extremely stressful and very unpleasant. And so this can stop all of that. You'll be in bankruptcy court, and the court will work to protect you. So again, a very attractive feature of the bankruptcy process is probably what convinces a lot of folks to declare bankruptcy, because it stops harassing phone calls and that sort of thing that's driving them crazy. If a creditor were to violate that stay and go ahead and try to collect a debt without permission, that can get him in big, big trouble. So as a creditor, you want to be very careful. If your debtor has declared bankruptcy, you have to go through the bankruptcy court, and you cannot do an end run around that, or you'll get in big doo-doo. So we don't want to do that. The entire reason that we have a bankruptcy system is to get the court to issue an order that will discharge or forgive some of the debtor's debts. That's usually why the debtor goes into bankruptcy in the first place, is because they're under a mountain of debt that they can't climb out of, and so they want the court to help them by getting rid of some of that debt so they can write that off. And so that's the ultimate goal for a debtor in bankruptcy, is to get that order of discharge. Before we get there, the court will tally up all the assets that actually belong to the debtor to see what is actually on the positive side of the ledger. And any secured creditors will get their collateral, typically, because they have priority in the collateral over unsecured creditors. And so if somebody has a purchase money security interest in your bass boat, they're probably going to get your bass boat. That's not going to be sold to pay the other creditors, and so that creditor will get priority in that collateral. Then the remaining unsecured creditors will get at least some of their debt repaid out of the remaining assets. And so if there's a bank account or something, that's not encumbered by security interest, we'll divvy that up and pay that out to the creditors. Usually they will get pennies on the dollar, but at least they will get something, usually a pro rata share based upon how much the debtor owes the different creditors. So let's take a look at an example here of a bankruptcy proceeding. In our example here, we have Wilma, who declares bankruptcy. She owes money on her car, has a loan which was used to buy a fishing boat, and has $50,000 in unsecured credit card debt. The bank, which made the car loan, has a security interest in her car, so it can repo the car to satisfy the debt. The bank that made the boat loan has a security interest in her boat, so it can repo the boat and sell it to satisfy the debt. However, Wilma still owes $50,000 to two credit card companies. She owes $10,000 to Visa and $40,000 to Discover. However, she only has $5,000 in assets left. The court can take those assets and pay off the creditors pro rata, which means in proportion to the size of the debt they are owed. Of the $5,000, Visa will get $1,000 and Discover will get $4,000. The court will then discharge the remaining $45,000 in debt, which means that Wilma no longer owes it, will never have to repay it. Wilma has a fresh start, although her credit rating is in the toilet for about 10 years. So this is kind of how a typical bankruptcy might work. The secured creditors do have security interests in these particular pieces of property, so they can seize those and they will have priority in those. Of course, if the boat sold for more than it was worth, more than was owed on it, that excess could go back into the pot to help these unsecured creditors out. But in this situation, that didn't happen. But we will try to pay off these unsecured creditors who are kind of left holding the bag here as much as we can by divvying up these assets that aren't claimed by a secured creditor or any excess from selling collateral on a secured debt, and then divvy that up in proportion to the amount of debt owed to these various creditors. And then when we have squeezed Wilma as hard as we can and gotten all of her assets divvied up, of course, we'll leave her with a little bit. We'll get into that in a minute, but then we'll discharge the rest. And so then she has a fresh start. It's a brand new day, and she can go, hopefully, make better financial decisions, such as not racking up $50,000 in credit card debt and not get into this situation again. If you are a debtor who's in way over your head, bankruptcy can be kind of a magical process that will discharge your debts and get them out of your life. However, it's not all powerful. There are some debts that can't be discharged in bankruptcy. Most can be, but some can't be. And the 2005 revisions to the code tightened this up quite a bit. If you owe money to Uncle Sam via taxes or state income taxes that were due within 3 years prior to filing, you can't discharge those. And so, of course, it's the government running the bankruptcy system. If they don't want to discharge their debts, they don't have to. And so if you owe money to the IRS, it's pretty hard to get rid of that sometimes. Also, there are rules about not discharging alimony to your ex-spouse or child support. And, it's kind of understandable. You have a family to support. They're not going to let you treat your kids like some other creditor, like Visa or something. If you owe money to your kids for their upkeep and maintenance and health and education and all those other things that kids need, they're going to probably not let you out of that. And there are other categories as well. Again, we're not going to get way down in the weeds trying to figure out all this stuff. We're just giving you an overview of bankruptcy, but keep in mind there are some kinds of debts that cannot easily be discharged through bankruptcy. Interestingly, though, most tort claims against you can be discharged. If you have committed a tort and someone has sued you because of that, that's treated like just another debt, basically. And so there have been a number of companies who have been sued because of defective products. For example, their widgets explode and hurt people. Well, they'll end up declaring bankruptcy rather than face millions of dollars in civil judgments. And so if they see the writing on the wall, if their widgets are exploding and hurting people and they keep, a new lawsuit is filed every 10 minutes, they see how things are going. They realize they're going to get completely devastated financially by all these lawsuits. They can just declare bankruptcy. And so someone who has a tort claim against a debtor is considered a creditor and is treated accordingly. So you'd have to go into the bankruptcy court and file a proof of claim for your tort claim, just like their credit card company or their bank or whoever would have to file a proof of claim. And you're considered to be just another creditor. And so your tort claim will go into the mix there with all the other claims by the various creditors. And so that can be kind of an escape mechanism for folks that have committed bad torts. And people do this, individuals can do this too. It's not just a company. If you, run over a bunch of school kids, on a field trip, and you're a drunk driver or something, and you get hit with all these lawsuits for millions of dollars and you'll never be able to repay, you can declare bankruptcy, and that will shield you from some of those claims. And so it's kind of unfortunate in a way because there are people with legitimate tort claims who can get stiffed through the bankruptcy process, but that's the way it's handled. It's just handled like another claim by a creditor, basically. So anyway, that is in the mix as well. When the debtor files for bankruptcy, all the property he owns at that time, except for things that are exempt, become part of the bankruptcy estate. And the estate is basically the entire collection of the debtor's assets, which the court will then administer and try to figure out how to divvy up in order to satisfy the claims of the creditors. So the property that's in there, that's why the court is administering it, is to try to figure out how to pay off as many claims as we can. The court will end up deciding which creditors get what items of property, how much money, etc., out of the bankruptcy estate. And again, that excludes things that are exempt. And so not all of your property ends up in the bankruptcy estate. You are allowed to keep certain things, the clothes on your back, like maybe part of your vehicle allowance and your home allowance and whatever. We'll look at that in some detail a little bit later. But most of your assets are going to end up in this bankruptcy estate, which the court will then try to take control of in order to satisfy all the claims against you. Well, keep in mind, we do have exemptions in there because the bankruptcy code is designed to give debtors a fresh start, not to leave them destitute. What good would the bankruptcy court do if it would, discharge all your debts and give you a fresh start, but not leave you with, any means to get back and forth to a job, anywhere to live, any food, any clothes, anything else? If it took all of your assets and divvied them up to your creditors and left you in the poorhouse, and that's not going to solve anything, really. That's just going to put you, as a ward of the state or something where you're living in a homeless shelter. We don't want that. And so the bankruptcy code and does let you keep certain property exempt from being included in the bankruptcy estate, which means it will not be used to pay off debts. And so the debtor will get to keep this exempt property, will still own it after coming out of bankruptcy. And so once the debtor comes out of bankruptcy, they will have a little bit of money, hopefully, somewhere to live and some food to eat, maybe some way to travel so that they can get back and forth to a job and start earning an income again. Because we don't want to, this isn't about punishing people. It's about making them productive members of society again by giving them this fresh start. And so if we took everything away from them, they wouldn't have that. And so we have to leave them with a little bit that they need to provide for themselves and their families. And so there is some property that's exempt. It's not great, but there is some that they're allowed to keep. Let's look at some example exemptions here. And these vary from state to state, but this is kind of just a typical look at what it might be in a particular situation. For example, they might allow you about $3,000 worth of value in a car, and that's kind of typical. So, you're not able to keep your Lamborghini. You are allowed to keep at least some kind of hoopty so you can get back and forth to your job because we want you to be productive and provide for your family. They might allow you close to $10,000 worth of clothes and other personal household furnishings and personal property. Those should be on one line there. Hopefully you don't have $10,000 worth of clothes, but anyway, they basically just, your furniture, your coffee table, your entertainment center, maybe if it's not worth too much, just the things that you would ordinarily furnish an apartment with or something. Nothing luxurious, but enough that you're not completely out on the street. So your creditors aren't going to take your toaster or your, coffee table or whatever. And your clothes off your back, literally, you're allowed to keep some of that stuff. Also, some government benefit payments and retirement pensions are kept as exempt. And again, that's the government. If they're paying you the money and they want you to keep it, they can do whatever they want. And so the bankruptcy code does allow for some of that. Although the bankruptcy code is federal law, it allows individual states to create their own list of exemptions, some of which are more generous than the ones in federal law. And so again, this is typical stuff, but some states might be a little bit better than others on that. And so a debtor in bankruptcy may be able to choose to use the state exemptions to let him keep more of his stuff rather than go with the federal exemptions that are kind of the default rule. And so if the state has redefined that in a favorable way, that may help you out. One very important exemption in bankruptcy is what we call the homestead exemption. And that's the property the debtor owns and uses as a principal residence. In other words, he lives there, and that's his house, wherever he happens to live. And so there is a homestead exemption. We don't want to make you homeless. We want you to have a roof over your head when you come out of bankruptcy. However, the homestead exemption is not unlimited. Most states will allow anywhere from $20,000 to $100,000 worth of property to be counted as a homestead exemption. And again, you can kind of see the logic of letting states define this a little bit because different states work differently. If you want to live in Metro New York, probably the $100,000 isn't going to get you very much. If, on the other hand, if you have that $100,000 in Neosho, you can have a pretty nice house. And so the different states have different economic realities and real estate markets and stuff, so they have the power to adjust this a little bit to kind of fit their local circumstances. And so most states put a dollar amount on this and let you have a homestead exemption up to a certain amount. So what would happen is if you live in a state that only allows a $20,000 homestead exemption, but your house is worth $100,000, you may have to sell your house. And then once your house sells, they will let you keep $20,000 from the sale. The remaining $80,000 will go to your creditors. And so you'll be able to use the money that you got, that $20,000, to get a place to live. So you can at least, rent an apartment, for quite some time. It just, of course, the place you end up with is not going to be as nice as the place that you were used to. And so it's kind of, trying to balance those interests there. You shouldn't be able to, live in a mansion while you're stiffing your creditors, is the thinking. But we don't want you to be homeless either. And so they let you keep some of that, but then put the rest of it in your bankruptcy estate to satisfy your unpaid debts. Some states take a different and somewhat interesting approach to the homestead exemption that some people have learned to take advantage of, probably more than they ought to. Florida and Texas do this, and Arkansas is somewhat this way as well. In those states, rather than having a dollar limit on the homestead exemption, they will have an acreage limit. And so For instance, you might be able to keep, if you're out in the country, they'll let you keep 40 acres. Or if you live in town, they'll let you keep a quarter acre as your homestead. And it doesn't matter how much that property is actually worth. They're just looking at how much land there is, how much of the Earth's surface. They don't care what's on it. And so that has turned Florida and Texas into debtors' havens, because debtors could go down there, sink all their money into some kind of luxury mansion, declare it their homestead, and then they would be able to protect it from creditors. Because again, as long as you put it on that quarter acre you declare as your homestead, it doesn't matter what you build on it, it's going to be protected as your homestead. And so let's say that you're thinking of declaring bankruptcy, and so you take whatever money there is in your bank account, you put it on a new addition to your house that's on your quarter acre that you're going to declare as your homestead. Your bank account, it wouldn't be safe from creditors if you declared bankruptcy. It would be included in your estate. However, your new sunroom that you build onto your homestead, that's going to be exempt from your bankruptcy estate. So you can see how people could kind of sink all their money into this homestead, and that would allow them to shield it from creditors. And so that can be abused. And there's been some stories of folks that would go down to Florida and buy some beautiful mansion, with a good view of the ocean, and have, played everything in the bathroom in marble and gold and whatever, and, build a swimming pool, and as long as it's on their quarter acre, they get to shield it from creditors. And so that could be unfair, but that has turned these states into places where debtors like to go live, because they can sometimes take advantage of this. And so, again, it can be abused, but different states will treat it differently, and depending on how they want to handle it. Well, speaking of screwing your creditors over, sometimes a debtor will try to be sneaky and move property around, either before or after declaring bankruptcy, in order to keep it out of the reach of creditors. And so if the debtor transfers property to one creditor and stiffs another creditor in the process, and that's what we call a preferential transfer. And so there might be situations where you're okay with one of your creditors getting a particular piece of property, but you don't want some other creditor to get it. And so you will try to move things around in order to basically cheat one creditor and reward another for whatever reason. So let's look at an example of where that might take place. Mo declares bankruptcy. He owes $90,000 to the Bank of Wheaton and also has borrowed $10,000 from his grandma. After filing his petition, he gives his boat to grandma in order to pay off his debt. The Bank of Wheaton cries foul, because Mo's boat could have gone toward paying off his debt to them. And so you can see why Mo would rather pay off his grandma than some bank. And so he's basically playing favorites here. And under bankruptcy, we're not supposed to do that. What Mo did here is called a preferential transfer. He unfairly paid off one creditor, his grandma, at the expense of another creditor, the bank. Well, let's say that Mo's boat was worth $10,000. Well, Mo's debt to grandma is then fully paid off when he gives her the boat. However, if he had not given her the boat, it would have been part of his bankruptcy estate, and his creditors would have been paid off pro rata. So what should have happened here, let's say the boat was Mo's only asset. He owed a total of $100,000, but he owed 90% of that to the bank and only 10% to grandma. So in bankruptcy, the boat could have been sold for $10,000. Then the proceeds would be split between the two creditors in proportion to the debt that they owed. And so if we did that, the bank would get $9,000 and grandma would only get $1,000. And so that's what should have happened. We should have paid off the debt pro rata like that. Now that's assuming, of course, that nobody had a security interest in the boat. That would have completely changed our facts. We're assuming that both of these are unsecured with respect to this boat. If that is the case, then that boat should have been sold and the proceeds split fairly between these two creditors, rather than rewarding grandma and stiffing the bank. And so we're not supposed to do that. And again, that's just not fair what Mo tried to do here, give grandma preferential treatment. The bankruptcy code gives creditors the power to object to a preferential transfer, and the court can void the transfer if it meets certain requirements. What that means is that the bank could ask the court to make grandma give that boat back, so it would become part of the bankruptcy estate. And so the bank sees what's going on, complains to the bankruptcy court judge. The judge would examine the situation, figure out that the boat should not have been given to grandma, make grandma give that back to give that boat back, and then it would become part of the bankruptcy estate. then the court could sell it, split the proceeds like we were just looking at, and then everyone is treated fairly. And so there are ways of undoing those preferential transfers because, again, we want to treat everyone fairly through the process. The bankruptcy court also has the power to undo certain other shady deals called fraudulent transfers. This is what happens when a debtor gives property to someone else solely to keep it out of the bankruptcy estate and away from the reach of creditors. To be defined as a fraudulent transfer, there are 3 requirements for that. First, the debtor has the actual intent to hide the asset from creditors. In other words, that's why the transaction was made, just to get it away from creditors. And so the debtor is actively trying to screw his creditors as much as he can. Second, the debtor is insolvent at the time of the transfer. In other words, he has more debts than assets, and so he is truly insolvent, as bankruptcy defines. And third, the debtor received less than reasonably equivalent value for the property. Let's take a look at an example to kind of show how this might happen. Let's say that we have Clive, and Clive declares bankruptcy. However, he has a nice Harley motorcycle that he doesn't want his creditors to get. Clive makes a deal with his buddy Jack. Jack will sell the Harley to Jack for a case of beer. Clive transfers title to the motorcycle to Jack. The Bank of Granby, one of Clive's creditors, finds out about the sale. The bank explains to the court that Clive was insolvent when the transfer of the motorcycle was made, that he only did it to stiff his creditors, and of course that the Harley is worth much, much more than just a case of beer. The court can declare the transfer fraudulent and undo it, transferring title of the Harley back to Clive. It will then become part of the bankruptcy estate and can be sold to pay off debts. And so in this situation, Clive is trying to be pretty smart about this. Either, one of 2 things. He may just say, well, I'm going to lose my motorcycle anyway. I would rather Jack have it than the bank. Or he could have worked out some kind of deal with Jack to where Jack will sell it back to him after he comes out of bankruptcy and his debts have been discharged. So either way you slice it, we're trying to screw creditors, and so that's not good. And so when the bank gets wind of this, they can have the court undo this fraudulent transaction, which was done just for the sole purpose of sticking it to the creditors. That's the only reason he sold this Harley. Now, if he had sold the Harley, of course, for what it was actually worth, we would just take the money that he got from the Harley, put it in the bankruptcy estate, and no one would care, would he? If he had gotten reasonably equivalent value for it, then we would have let that transaction stand, but that's certainly not what was going on here. I'll make a little side note here. Fraudulent transfers can happen outside the context of bankruptcy, too. And that might happen, for instance, when someone is being sued and expects to lose the case and suffer some kind of big judgment. If that were to happen, they might suddenly feel generous and start selling, quote unquote, or giving away their property to friends and family so that when the creditors show up, they won't find anything to seize to satisfy the judgment. And this happens sometimes. You can imagine, for instance, there was some, family-owned business or something, let's say, that got sued. Let's say they were making deliveries, and one of their delivery drivers ran over a van full of old blind people who were going to the senior center. They get slapped with 100 different lawsuits, all asking for $10 million, and clearly they're going to go out of business. And so they might start giving things away, or selling things at a bargain to friends and family or whatever they could to try to get rid of all their assets. And so when they actually lose the lawsuit and the plaintiffs show up, with freshly minted judgments in hand or trying to seize property, there's nothing to seize. And so in order to stop that, Missouri and many other states have adopted a uniform law called the Uniform Fraudulent Transfers Act, or UFTA, which I always thought sounded kind of Norwegian, like a greeting or something, but be that as it may, UFTA allows you to undo these fraudulent transactions. And so creditors can file suit in state court to have such a transaction undone and then get the property back into the hands of the original debtor out of the hands of the person that it was given to. And kind of the same criteria apply there. If it was clearly done with the intent of screwing the creditors and it was not done for reasonably equivalent value, in other words, whoever got it didn't really pay what it was worth and all that, then we can have a fraudulent transfer that the court can undo. And so if you're ever sued and have the bright idea of, oh, I will just transfer all my stuff to my brother-in-law and try to get it out of my estate, well, it probably won't work because they will find it and track it down and use UFTA to get it undone. So Anyway, there are means for dealing with people who are trying to be sneaky and hide their assets. Now we're going to take a look more specifically at the bankruptcy code. As we mentioned earlier, there are several different chapters, and you've probably heard of some of these just in polite conversation, but they all do a little bit different things, and some of them are available to different sorts of debtors. And so we'll just take kind of a really quick tour through the bankruptcy code looking at these different chapters. And here they are in summary. We have Chapter 7, which is a liquidation type. We'll look at what that means in a little bit, which can be used by either individuals or businesses. We have Chapter 9, which is a reorganization, which is used by municipalities and other local government entities. We won't spend a lot of time on that, but we will take a brief look at it. Chapter 11, we hear about in the news quite a bit, usually when some huge company declares bankruptcy. They're not actually going out of business, they're just going through a Chapter 11 reorganization. That can be used by either individuals or businesses, but it's usually businesses that do it because it's a little bit longer and more involved. Chapter 12 is a special one. It's a reorganization that only works for family farmers or family fishermen. We'll take a brief look at that. And then Chapter 13 is reorganization only for individuals, not businesses. And so, again, we will take a look at what these different ones do, but that's how the bankruptcy code is set up. And so you hear someone's going through Chapter 7 or Chapter 11, and this is what we're talking about. It's a chapter of the bankruptcy code. Let's look now at Chapter 7, liquidation. When you go into bankruptcy, you have to choose which chapter of the bankruptcy code to file under. That will determine the type of bankruptcy you have. And there are two basic types. Chapter 7, which we're going to look at in some detail here, is a liquidation type of bankruptcy. And that means that the debtor's non-exempt assets are liquidated, which means they are sold off and converted into cash, and that cash is then used to pay off the creditors. And so rather than, try to kind of reshuffle your debts and keep on living your life as you've been living it, they will just say, whoa, Nellie, let's stop this train, let's sell all the assets and try to wipe off the rest of the debts, and then you'll just start over from scratch, basically. Well, Chapter 7 is a liquidation type bankruptcy for both individuals and businesses. In there, the debtor will end up keeping his exempt property, whatever that happens to be defined to be. Secured creditors will be able to repossess property in the debtor's possession that was used as collateral. The rest of the property in that bankruptcy estate will then be liquidated, and the money will be split pro rata among the unsecured creditors. Then at the end of the process, the court will likely discharge most of the debtor's remaining debts. And so, just in a nutshell, that's what we have going on here. And the individual or business that declares Chapter 7, if it's an individual, they're going to lose a lot of assets. Anything that's not under one of those exemptions, that's going to be sold off to pay the creditors. If it's a business, on the other hand, they're going to go out of business because all their assets are going to be sold. They cannot continue in business any longer. So it's not a pleasant process, but at the end of that those debts will be discharged. And so that's a good thing. We'll get rid of those debts and just kind of move on. With the Chapter 7 bankruptcy, once the debtor is discharged, the debts are forgiven, and the debtor will never have to repay them. So once you get through the whole process there, the bankruptcy judge will discharge whatever's left of the debts, and they're gone. And the debtor's never going to have to repay them. They are forgiven. And that's true even if the debtor wins the lottery the day after the discharge. It doesn't matter. Those debts are canceled. And so that's pretty final. And if you're a debtor, that's a really cool thing to have the court step in and just say you don't owe that debt anymore. So that's how the Chapter 7 works, and it certainly does benefit those who go through it. It's a painful process. You get back to square one financially with very little to your name except whatever fit under an exemption, but you do have those debts wiped away. And again, since the debtor can walk away from a Chapter 7 bankruptcy basically debt-free, some folks found that to be a pretty enticing proposition when they got really underwater with a lot of debt. And lots of creditors were very unhappy with the law since they often got stiffed when debtors declared a Chapter 7 bankruptcy and were left being forced to take really pennies on the dollar and to satisfy their debts. For every dollar of debt, they might get 10 cents or something. And so they weren't real happy about that. So we did have that 2005 revision, which added some stringent new qualifications before a debtor could actually qualify for Chapter 7. And so if you didn't qualify for Chapter 7, we could stick you in some other provision of the bankruptcy code that was less debtor-friendly, that might not wipe away your debts forever in quite the same way. So when somebody declares bankruptcy and tries to use Chapter 7, the court's going to have to look at how much income they make and how much money they owe and all that stuff to make sure that they actually do qualify for Chapter 7. And basically, the court has to make sure that the debts are so far, in excess of the debtor's income that there's really no way that the debtor can ever pay that money back. If the debtor does make enough money to where he might be able to stay afloat if his debt was somehow restructured, then the court can transfer him into one of the other chapters that doesn't have such generous discharge provisions. And so just because you want to be in Chapter 7 doesn't mean that you necessarily will get to be in Chapter 7 if the creditors gripe about it or the court decides you don't really fit in there. And that's one thing that the 2005 revisions kind of made harder to deal with, is getting into Chapter 7 is a little more difficult than it used to be. The Bankruptcy Code has provisions for establishing priority among creditors. We saw how that works under Article 9 last week. And so there's a very similar kind of system that works here. And that's one reason I put these chapters back to back, is because some very similar concepts between secured transactions and bankruptcy and how that priority is determined. We already talked about a secured creditor normally has priority in the collateral. So if you loan money to Billy Bob for his bass boat, you're normally going to have priority in that bass boat when he declares bankruptcy. However, if the collateral is worth more than the debtor actually owes to that creditor, then the creditor is oversecured. In other words, the collateral is worth more than is actually owed. So if Billy Bob had been making faithful payments, for a few years on his bass boat, that boat might actually be worth more than is still owed to that creditor. And so we'll say the creditor is oversecured. They have more security than they really need. And in that situation, and when we sell the bass boat and then pay off that secured creditor, then we can use the excess from that, and that will become part of the bankruptcy estate and can be used to satisfy claims from other creditors. And so if Billy Bob, had a $10,000 bass boat, he's already paid off $5,000 of it. Well, then when the lender of the bass boat, sells it, there'll be $5,000 left over. And so he can that'll be put back into the bankruptcy estate, and that $5,000 can then be divvied up to pay off other creditors. However, the collateral is maybe worth less than the debt that's actually owed. And if that happens, then the creditor is undersecured. And so that's an unhealthy situation to be in. So in that situation, the creditor gets the collateral transferred to him, but then the creditor becomes an unsecured creditor on the difference between the amount that's actually owed and the value of the collateral. So let's look at an example of how this could work. The Bank of Reeds loans Mike $15,000 to buy a bass boat and takes a security interest in the boat. A year later, Mike declares bankruptcy but still owes $10,000 on the boat. The bank is a secured creditor and has priority in the boat. However, Mike didn't take good care of the boat. It capsized twice and ran aground a couple of times, and now it is ugly and leaking is only worth $5,000. So it's worth less than is owed on it. In the Chapter 7 proceedings, the bank is able to repo the boat. However, the bank is still owed $5,000 because the value of the collateral is worth less than the debt that was owed. And so the bank is able to get that boat, sell it, and keep the $5,000, but they're still owed $5,000 because he actually owed $10,000 on that boat, and it wasn't worth as much as he owed on it. Well, now, for the rest of that debt, the bank is going to be undersecured. So for the rest of that debt, they'll become an unsecured creditor for the amount that's left. And so we take the $10,000 they were originally owed when he declared bankruptcy. We will subtract the amount the collateral sold for, which was $5,000, and thus we have $5,000 left that Mike still owes the bank. And the bank will be able to participate in the bankruptcy proceedings as an unsecured creditor for $5,000. And so the bad news is they don't have priority anymore for that $5,000 that's left. But the good news is that they may still get something back, because if Mike, has a bank account or a retirement fund or something else or even other personal property that they might be able to seize and sell, then they will be able to recover some part of what's left. But they were only secured on the boat, and so they were undersecured because that boat, even after they sold it, he still owed them money. And so it can be a bad situation for a creditor, but at least they will still be able to stick around as an unsecured creditor for the amount by which they were undersecured. All right, well, after we have the secured creditors taken care of, they have repoed whatever they need to and sold it and satisfied as much of their debt as they can, or if they had excess, if they put it back in the pot there. Then we have to deal with the unsecured creditors. And the bankruptcy code gives priority to certain types of unsecured creditors, which are divided into what we call classes. And so we'll have like class 1 creditors and class 2 creditors and class 3 and so on. And the way that the code works, we have to pay off all the class 1 creditors before we go and pay any money to the class 2 creditors, before we go pay any money to the class 3 creditors, and so on. And so it gets kind of complicated sometimes. And creditors with claims on this list are called priority unsecured creditors. And so they're unsecured, but we're going to take care of them if we can. And the law has just made a determination that some creditors deserve to be paid back more than others, and so they're just given this designation of class 1 or class 2 or whatever. And so once we pay off everyone who's on this special list, then we get to what we call the non-priority secured creditors. So that's just an unsecured creditor with a type of claim that's not on this priority list. And so they will get paid if there's anything left, but they may very well be left out in the cold because we have to take care of all these different classes of priority creditors first. And again, I'm not going to go into great detail about who's in these different classes. You wouldn't remember it, and it's not that important unless you're actually dealing with a bankruptcy. But certainly it can be a big deal if you're one of these creditors trying to get classified. You know, if you can get classified as a class 1 creditor, you're going to be in pretty good shape. If you can't fit yourself into this list somewhere, then you'll be a non-priority unsecured creditor, and you're probably going to get stiffed because there's probably not going to be enough money to go around. So anyway, that's how the code is generally set up, trying to figure out who gets what out of the bankruptcy estate. Under Chapter 7, once all the money from the bankruptcy has been paid out to the various creditors, then the debts that are still unpaid can be discharged or just canceled, written off. They'll never have to be repaid. Once discharged, then a debt is gone forever. It's never going to come back. And as we mentioned earlier, even if the debtor wins the lottery the day after the discharge, he still won't have to repay his own creditors. Well, that's a really good deal if you're an individual, because basically you can start life over from scratch. It's a brand new day. You can go out and try to get your life back on track and work your job and try to live within your means and go on, and these debts will never come back to haunt you. It's a little bit different, though, if we're dealing with a business organization instead of an individual. If we're dealing with a business that's a corporation, an LLC, or something like that, the discharge doesn't work the same way. Those will be discharged, but those businesses will be completely liquidated. In other words, all their assets are going to be sold. They will be wound up. They will cease to exist. In other words, they have gone out of business. And so as a business, if you declare Chapter 7, you're going out of business. Because you'll have to stop, wind up all your operations, lay off your employees, sell all of your equipment and whatever you use to conduct your business with. All that's going away to pay off your creditors. And if there's anything left over, that'll be discharged, but it's not going to do you any good because you'll be out of business. It does work a little bit differently. It's a better deal for individuals and businesses in that sense because the business is going out of business if they go through a Chapter 7 liquidation, because liquidation means what it says. They liquidate everything, they sell it all, and there's nothing left at the end. And so for an individual, you have a fresh start. For a business, it's kind of the end of the road. So it does treat you very differently depending on what kind of entity you are when you go in to bankruptcy. Let's talk now about Chapter 13, which is individual reorganization. And we just saw what liquidation is like. It means selling or liquidating most of the debtor's assets and using the money to pay off creditors. And if it's a business, you liquidate everything pretty much and sell it all and go out of business. Well, the alternative to that is what we call a reorganization. And a reorganization allows debtors to restructure their debts in such a way that they can stay financially afloat and keep paying off their old debts. And so we don't liquidate everything. We don't sell off all their assets. We let them keep most of their assets, but we restructure their debts in such a way that they're not, in desperate straits anymore. Let's take a look at an example here of an individual in this situation. Trudy makes a good living and has a steady income. She has a home mortgage and a car payment as well as some credit card debt. However, she is keeping afloat and doing just fine. Then her car breaks down and needs a new transmission. Her son has to spend some time in the hospital, and the medical bills start piling up. Her refrigerator dies, and she needs a new one. And all of a sudden, Trudy has new bills she wasn't planning on, and her income is not enough to keep up with all the payments. And so Trudy is, being a hard little worker here, trying to, keep up with everything. She's paying all of her bills, but then bad stuff happens, and suddenly she's not able to stay afloat anymore, and she can't pay all of her bills. So there's going to be some overdue bills piling up. She's going to have to start stiffing creditors if something doesn't change, and so she is in financial trouble. However, Trudy is not what we would call broke. She's not technically insolvent, maybe, or maybe she is, but, she still has an income, and so, it's not like she's completely destitute. So she's fallen behind. She's not going to be able to keep up with the payments on everything, and so the money going out is more than the money coming in, but, she still has money coming in, and so all hope is not lost. So she could try to work something out with her creditors. She could pick up the phone and call MasterCard and say, hey, I'm really sorry, but can we work something out? She could call the hospital where, the medical bills are and say, hey, I'm really sorry, I'm poor, can we work something out? They may not listen to her, though. So they may be mean to her, and so she wouldn't feel like she had any alternative of just working things out directly with them. Liquidation, though, under Chapter 7 would really be too drastic. She has a regular income. She's not really broke. She may be technically insolvent because her assets aren't as much as her liabilities, but she can't afford the size of the payments that she used to be able to make. And so her financial situation has changed, and she just can't keep up now. Well, Chapter 7, if we do that, that's going to be pretty drastic. We'll leave her with whatever exemptions that she might be entitled to, but we'll make her sell everything else, and we'll end up discharging a bunch of debt. And so it might not work out good for anybody, because in that situation, she may lose more property than she would otherwise have to. The creditors might actually get stiffed, because once the Chapter 7 discharge comes into play, they would actually lose some debts, would never get repaid ever. And so if they would just work with her, she might be able to repay them eventually. And so Chapter 7 might be too drastic, so we'd have to look for something else. Well, Chapter 13 is that something else potentially, and it allows individuals in a situation like Trudy's in here to reorganize their debts in such a way that they'll be able to make payments and stay current on those debts. And Chapter 13 is available for individuals, not businesses, who have a regular income. There is a chapter, Chapter 11, which we do allow businesses to use for reorganization, but 13 is only for individuals. And again, they have to be holding down a job. They have to have some kind of regular income, and the debts must be mostly consumer debt, which means debts incurred for family and household stuff. Not to run a business. So if Trudy had gone out and taken out, $500,000 loan, to start a dry cleaning business or something, and that's why she was on the ropes. Chapter 13 is not appropriate for that. We're talking about things like medical debt, car payments, student loans, credit cards, that kind of stuff. So if most of it's consumer debt and the debtor actually has a regular income, Chapter 13 may be available for that. In the petition, the debtor must claim that he's either insolvent or just unable to pay his debts when they become due. So in other words, it could be genuinely insolvent, or just could have a cash flow problem to where we're having to pay out money faster than we're making it. Chapter 13 will then allow for an extension of debts. So in other words, you can lengthen out the term of the debt, give you longer to repay it, and thus have smaller payments. Or we could do what's called a composition, which is actually a reduction in the amount that's due. So that's like discharging a part of the debt. And so we might discharge part of it, but we're not going to be writing them off right and left like we would with Chapter 7. It's a little bit different. And so people who don't actually qualify for Chapter 7, remember they did tighten up those restrictions to qualify for Chapter 7, oftentimes they will file under Chapter 13 because its provisions will apply to them if they still have an income. They're not quite as destitute as you need to be for Chapter 13. So 13 will allow you to keep your house, try to catch up on your mortgage rather than liquidate the house and just keep your homestead allowance. So that can be really good. And if you have a lot of equity in your house or just don't want to lose it, 13 could be a very much better deal for you because you don't want to have to lose your house and just keep your $20,000 or whatever your state allows you to have. And so it can end up being a better deal for consumers and for creditors as well, because again, they're not going to lose as much in a write-off. Like Chapter 7, 13 requires that you file a list of creditors and assets and then have a meeting of the creditors. Creditors have to file proof of claims, and so the procedures look very, very similar to what we saw with Chapter 7. Then the debtor will file what's called a plan of payment, which explains to the court how the debtor proposes to restructure his debt so he'll be able to get current on everything and stay afloat in the future. So you have to have some kind of business plan, basically, that makes sense for your personal financial dealings, showing that, okay, if we restructure the debts this particular way, my payments are going to be so much, I'm making so much money, I'll be able to keep afloat and get current on everything again. The plan might change the rights of creditors. It might, if this creditor signed on for a 10-year loan and suddenly this plan of payment says it's going to be lengthened out to 20, that's going to affect them significantly. And so they will get a chance to object to the court and suggest modifications. And so they'll have to get their say in there too and have a chance to be heard by the bankruptcy court and figure out, what's fair to the creditors and what'll work for the debtor. After the plan has been considered, the court can approve it. And if it's approved, the debtor will start making payments to the bankruptcy trustee, who will then distribute them to the creditors in accordance with the plan. And so the trustee kind of steps in as kind of a referee there to make sure that the plan is followed and everyone gets what's coming to them under the plan. After the debtor has made all the payments called for by the plan and is financially back on track, a process that could take up to 5 years, and then the court will grant a discharge. Now, this is the same word, but it's different than a Chapter 7 discharge, which erases the debts. A Chapter 13 discharge just means the debtor has completed the plan, is back on track, and is no longer bankrupt. And so we're out of bankruptcy. We've gone through this reorganization, and so we're better able to manage our financial affairs now, and we're not going to be insolvent or skipping payments anymore, and so we're back on track. That's kind of what this discharge means, and we're out of the bankruptcy plan. We don't have to make the payments to the trustee anymore. And so we're just out of that system. And so that's what Chapter 13 is designed to do, is help folks get back on track. And so it will modify the terms of the loans and things if it needs to in order to make it viable for the debtor to keep making payments and stuff. And then once that's been done, kind of turn them loose once the problem has been fixed. We also have another chapter, Chapter 11, reorganization. And again, Chapter 11, much like 13, provides for the reorganization of a debtor's financial affairs so that he can become solvent again and get back on track. However, while 13 is only available to individuals, 11 can be used by individuals, corporations, or other business entities, so it's open to everybody. And 11 is usually used by corporations. If you're an individual and you can get under 13, it's usually quicker and simpler to do it that way. But if you have a complicated financial set of affairs, 11 might be what you need. But when you're talking about a corporation, they're normally going to be using 11 if they can. Again, this can be started voluntarily or involuntarily by a creditor. So if the creditor is getting stiffed, for payments, they can drag their debtor into Chapter 11 bankruptcy potentially through an involuntary petition. So it can start either way, as we saw earlier. Once the case has started, if the court finds it would be in the best interest of the parties, it can switch the case over to Chapter 7 and liquidate instead of reorganize. That would happen in a situation where, let's say we have a business that's just horribly failing, it's terribly mismanaged, it has no prayer of ever making a profit, and it goes to court and declares Chapter 11 bankruptcy and says, I want to reorganize my debts. Well, the court can take a look at that and say, there is no way in the world you're ever going to be profitable, or you're never going to make money, or no matter what we do, reorganization-wise, we're never going to be able to put you in the black so that you can pay off your debts. And so they could switch it over to a Chapter 7 and liquidate instead. So it just depends on, what serves the best interests of all the parties in the situation. We're not going to play around trying to reorganize a hopeless business and make the creditors wait, many years, and to get paid back through a reorganization that we know going ahead isn't going to work. And so we can convert it to a different chapter if we need to. Like we saw under 13, Chapter 11 allows a debtor to reorganize their finances, have some of their debts discharged, and even get out of contracts that are unprofitable. For example, car companies have done this before. An automaker might have a contract with its employees union that has it paying out higher wages and benefits than it can afford. And so we'll have this happen sometimes. And car makers are kind of notorious for this, that they'll get to talking with the auto workers union or whoever, and they'll agree to pay really good salaries to their workers, which that's great. But it'll turn out later that the economy changes or something, they can't afford it, and they'll be stuck paying these high salaries and losing money every month. And so the bankruptcy court has the power to tear up contracts like that and rewrite them so that the company can pay employees less and become solvent again. And that's mean to the employees, but it also keeps the company in business. And if the company went out of business, then that will hurt the economy and all the employees will be out of work. And so sometimes this is preferable to letting that happen. We'll give the court the power to do this through the Chapter 11 reorganization. One very attractive thing about Chapter 11 is that the debtor gets to keep possession of his assets. And because of that, he gets to keep operating his business even while he is going through the bankruptcy process. And typically, the trustee is not going to step in and take control unless it is shown to the court that the debtor is trying to defraud creditors or is doing a really bad job managing his assets. And so a business can declare Chapter 11 bankruptcy, and there'll be a trustee appointed, but the company will get to keep managing its own affairs usually, as long as they're doing a pretty decent job of that without the trustee stepping in and getting in the way too much. And in fact, customers of a business that is in bankruptcy probably won't notice any difference from their services just because the company that they're dealing with is in bankruptcy. So if a store is in Chapter 11 bankruptcy and you walk into the store, you're probably not going to notice anything different probably. And this has happened quite a bit over the last several decades with major airlines, and they are notorious for this. They're just really hard to make money consistently, and airlines will deal with the pilots union and get into bad contracts where they're paying the pilots too much, and they'll get into the negotiations with the airline mechanics union and pay them too much, and then oil prices will spike and they can't afford to fly their jets anymore, and so then they'll oh no and declare bankruptcy. And they'll go through the Chapter 11 bankruptcy and come out the other side and have restructured all their contracts that they probably shouldn't have entered into in the first place, and life will go on. And so if you're flying on one of these airlines, you may not even notice any changes in the operations of the airline, even though the airline is in bankruptcy. And so it's kind of neat in a way. It allows businesses to continue operating even though they are technically bankrupt. And as I said, if you're dealing with that business, you might not even notice any difference along the way. And so then once they come out the other side, all their debts have been reorganized to where it's more sustainable for them to carry that debt load. They can come out of bankruptcy and continue on with business as usual. With Chapter 11, just like the other chapters, you file a petition to get the case started, and that will trigger the automatic stay that will prevent the debtor from most actions by creditors to foreclose on the assets and collect the debts, and so that you have that same protection. And after all, the debtor is trying to stay in business during the bankruptcy, and so you don't want creditors coming in and seizing assets of the business. They're trying to stay in business, and we want them to stay in business. It doesn't serve society or the economy or anyone else if this business goes belly up and has to lay off all its employees and all that. We'd all take a hit. So this is designed to keep the business operating, and that stay will help keep the business operating by protecting it from actions of creditors to come seize property or whatever. If the debtor has contracts that have not been fully performed, the bankruptcy code allows the debtor to either accept those contracts or reject them. And so that's kind of nice if you're the debtor. If it turns out you can't afford this contract that hasn't been fully performed yet, you might be able to reject it and get out of it. And so if a contract you've entered into turns out to be unprofitable, you can potentially get the court to let you tear it up and get out of it without fully performing it. Because, again, if you fully performed it and that, forces you out of business, that wouldn't be good. And so the court can allow you to get out of that contract potentially. Here's an example we can look at. Acme Incorporated signs a 20-year lease for a really posh office space here in a downtown skyscraper. And it's really feeling high on the hog here. Times are good. Well, then 5 years later, the business is barely keeping afloat and can't afford the rent anymore on this office space. Well, since the lease has not been fully performed, the business can go into Chapter 11 and then get out of the lease and move into offices that it can afford. And so in this situation, it's mean to the landlord and to let Acme get out of this lease that hasn't been fully performed. But on the other hand, would you rather have a fully functioning Acme Inc. that can provide jobs for its employees and add to the economy, in crappy office space in the suburbs, or force it to stay where it's at in the downtown skyscraper and go out of business and liquidate, and everyone loses their jobs. And so the alternative is better here to let them get out of that contract. And so Chapter 11 allows you to do things like that. And we saw this when I mentioned the airline example, but many bankrupt companies also take advantage of this provision to modify union contracts that have them paying large sums of money for employee and even retirement benefits to retired employees and things like that. And auto companies and airlines both do this sort of thing. They'll have unionized workforces, and so they'll get into contract negotiations with their employees. And it might be a situation where, the union plays hardball and will strike if you don't take our terms, and the company doesn't want to have a strike, and so they'll agree to something they probably shouldn't. And then a few years later, they can't afford it, and so they may have to go through Chapter 11 to get a court to make this union contract something that they can actually live with. And so we'll see that happen in some companies. Unfortunately, it seems like bankruptcy is almost part of their business plan, especially the airlines are notorious for that. It just seems like they all take turns declaring bankruptcy. So anyway, this isn't all that uncommon, actually, in business that these large companies, a lot of them have declared bankruptcy over the years and come out the other side perfectly fine and happy and continue on for many more years. Well, moving along with the Chapter 11 process, a debtor gets to file a plan of reorganization that explains to the court how the debtor plans to get back on his feet financially. So the debtor in this plan can propose that some of the debt stay and others be discharged, can propose to the court that certain executory contracts be rejected while others remain in place, and the court will then appoint committees of creditors, which are made up of representatives of the different classes of creditors, such as secured and unsecured, and these committees will have the opportunity to object to the plan. And so the debtor will come up with the plan and say, hey, everyone, what do you think about this? And give it to the creditors, and they'll get a chance to gripe about it, and then the judge will decide what to do. So after the creditors have had their say, the bankruptcy judge has the ultimate decision-making power, and his job is to make sure that the plan is in the best interest of everyone, the debtor and all the creditors too. Well, if he finds that it is, and if the creditors agree, the judge will confirm the plan and put it into place. If one class of the creditors objects and still doesn't like it, but the court still thinks it's a good idea, he can force them to accept it and still put it into place. And so the court will listen to everybody, but getting unanimous agreement on something like this isn't always possible. And so if the court decides, well, I know you don't like it, but I still think it's a good idea, they can go ahead and accept the plan and put it into practice, even if some of the creditors object to that. And when the court forces the creditors to accept this plan, it's called a cram down. Basically because the judge is cramming it down their throats whether they like it or not. And so they can gripe about it, and they may get the court to make some changes to it, but ultimately the court gets to decide what's in the best interest of everybody. So, of course, the judge could also take their objections into account and modify the plan and try to make everyone happy. And of course, they would rather do that rather than have somebody be upset and have to do a cram down. But the court certainly has that power if they choose to do that. Once the court puts the plan into place, the debtor will probably be able to get rid of some of its most burdensome debts, and the ones that are really causing it trouble, and be on a much more solid financial footing with the rest of its debts. And so it'll be able to continue making payments and stay on financial track there. And so hopefully our goal is to have the business come out of the bankruptcy solvent and financially profitable. We want them to be able to make money, keep employing people, doing all those things that a healthy business does. And if they are able to do that, that's good news for everybody. Some of the creditors are going to get the shaft. That's unfortunate for them when their debts may be discharged. But on the whole, for society, it's better to keep a business around that has some kind of profit potential and keep it going, adding to our economy, creating jobs for people, paying taxes, all those things good businesses do, rather than force them to liquidate, go out of business, and people lose their jobs. And so we would much rather go through this Chapter 11 organization, and even if they discharge some of the debts and stiff some of the creditors, if we can keep that business around, keep it afloat, keep it providing jobs and doing all the things that businesses are supposed to do, it's going to be far preferable until they go out of business or forcing it to liquidate. And so that's really what Chapter 11 is all about, is letting businesses that have kind of lost their way financially get back on track, and become profitable once again. And so we certainly want to satisfy the creditors as much as we can, but it's also very important to make sure that this debtor comes out the other side of the bankruptcy solvent, basically, and able to pay its bills and continue on functioning as a normal business is supposed to. Chapter 12 is a special chapter of the Bankruptcy Code that's not open to everybody, and around here we'll be dealing with family farmers mainly who use this. It's only designed for a special type of debtor, is really what makes it special. It's only used for family farmers, quote unquote, or family fishermen, and of course we don't have a lot of family fishermen in these parts. But if your family owns a boat or owns a farm and is trying to make a go of that, this is designed for them. And these terms, family farmer and family fisherman, are defined in the statute. And so you can look at the statute and see whether you qualify for that or not. The debtor can be an individual or a corporation, and some family farms, will form some kind of LLC or something like that. And if it's still a family farm, it's okay under the statute. But it has to have less than a certain amount of debt, and has to make a certain percentage of income either for farming or fishing, whatever the case happens to be. And so that's how the definitions work in the code. And Chapter 12 is unlike the other provisions we looked at. It cannot be started involuntarily by a creditor. It has to be a voluntary petition that starts a Chapter 12 proceeding. This is a reorganization type of bankruptcy, and so like Chapter 11, the debtor can remain in possession of his assets and keep carrying on the business during the bankruptcy proceedings, and that kind of makes sense. If you're a family fisherman and we seize your boat, you're not going to be able to fish, so there's no hope of you paying anything back. And with your farm, if we seize all your tractors and your combine and, whatever else you're using, or all your cows, or, whatever the case is, you're not going to be able to make any money. That doesn't do anybody any good. And so this allows that family business to stay in business through the proceedings. There is an automatic stay, just like the other chapters, and the debtor will have to file a plan of reorganization, like we saw with Chapter 11 and 13, which can include extending the term on loans to make the payments smaller, and can reduce the amount owed to unsecured creditors, and so we can write off some of those debts. And like in Chapter 11, the debtor can accept or reject executory contracts. Again, it's very similar. Once the plan has been proposed, the court will hold hearings, and creditors can show up and object to the plan, just basically like under Chapter 11. And so the court can modify the plan, confirm it after it's been accepted, or if the creditors are just hard to deal with, the court can use cram down to force it into place. But once the plan is in place, the debtor will hopefully be able to make his modified payments, and if the plan is followed, the court will issue a discharge eliminating some of those unsecured debts probably. And so for the level of detail that we're interested in our little foray into the world of bankruptcy, Chapter 12 and Chapter 11 look a lot alike, but Chapter 12 is specifically designed for these family farmers and fishermen, has some special provisions in there that helps them out, but pretty much it operates basically the same. One more chapter we're going to look at very briefly, and that's Chapter 9. Won't come up very often probably in a business career, but just wanted you to be aware that it does exist. It's used for municipalities and local government entities. So, for example, if the city of Neosho went bankrupt, it could use Chapter 9 to reorganize its debts and get back on track. We're not going to liquidate the city of Neosho, but we would allow it to reorganize, just like Chapter 11 or 12 or 13, and kind of maybe redo some of its contracts, maybe write off some of its debt, and allow it to get back on track to where it can pay its bills. Not just cities, but also it can be used by other creatures of local government, like a county, like Newton County, or, the Jasper Road District or something like that, whatever it happens to be. If it's some kind of local government entity, it can do this. The most famous example of this was, a couple of years ago, Detroit declared bankruptcy, Detroit, Michigan, using Chapter 9, and that was the biggest municipal bankruptcy in the history of mankind, probably. And Detroit just got into some horrible deals, and it couldn't pay its bills. And basically, the economy in Detroit tanked. A lot of the car industry went other places and did other things. And so Detroit was left with a shrinking tax base, a shrinking population. but it had incurred all these obligations to pay pretty generous benefits to its retirees, generous benefits to its current employees, had all these union contracts that it couldn't get out of, couldn't modify, and it tried to renegotiate all this stuff, and finally it just gave up and said, fine, we're declaring bankruptcy under Chapter 9, and did. And of course, the court has the power to tear up some of those contracts, and that's made some city employees and retirees very, very nervous because, you know, the income they were depending on may be at risk there. So this can happen. It's pretty ugly when it does, but hopefully you'll never be in charge of a city that has to file Chapter 9. But I just wanted you to be aware of that. So with that said, that's our whirlwind tour of bankruptcy. And please keep in mind, bankruptcy can get extremely complicated. You need a good bankruptcy attorney if you manage a large business that has to declare bankruptcy. It pays to have counsel that understands all the intricacies and the ins and outs, and it's, bankruptcy code's kind of like the tax code. It can change on you. And so definitely, I didn't do this to make you a bankruptcy attorney. I'm not a bankruptcy attorney, but wanted you to have a pretty good idea of what goes on here. Because chances are throughout your business career, at some point, you're either going to have a lender who is coming after you for something, or hopefully you won't have to declare bankruptcy, but you might, or you might, have a debtor that will declare bankruptcy. Now maybe you'll have some kind of idea of how the process works, and so that was my goal. So with that said, that wraps up this week of lecture notes. I'll look forward to talking to you again next week.